Welcome to For Better or For Court, Family Law in New Jersey.
Welcome back to For Better or For Court, Family Law in New Jersey with Miss Alex Claps. Alex is a partner at Heyman & Fletcher and a certified matrimonial law attorney who helps New Jersey families handle divorce, custody, and complex family matters with clarity and care. I'm Evan Mack, and today we're talking about what happens when the Division of Child Protection and Permanency, often called DCPP, becomes involved in a family's life. Miss Alex, welcome back, my dear.
Hi, Evan. How are you?
I'm well. So for listeners who may not be familiar, what is DCPP and what triggers its involvement in a New Jersey family?
So, as you said, DCPP stands for the Division of Child Protection and Permanency. It used to be called, a lot of people might know it as DYFS, which was the Division of Youth and Family Services. It got renamed, at this point, probably 15, 20 years. I mean, it's been renamed a long time, but people still use DYFS a lot. And it's a subdivision of the Department of Children and Families, which is a state agency that looks out for the welfare of children in New Jersey. And DCPP in particular has the task of investigating and addressing allegations of child abuse or neglect.
So how does DCPP investigation typically begin? What should a parent expect in those early stages?
So an investigation, I think, always begins with a referral. The referral source can differ wildly. Sometimes they're anonymous referrals. Sometimes they're referrals from teachers. Sometimes they're referrals from doctors. Sometimes you'll hear people use the phrase mandatory reporter, indicating that that's a person that's required to make a referral to the division. Here's a hint. Every adult in New Jersey is a mandatory reporter if you suspect child abuse. You have an obligation to call the hotline for the division and make the referral if you have a good faith reason to believe there's abuse. And there are some cases that trigger automatic referrals, whether or not anyone thinks there's a true risk of harm. So if a police report is filed or an allegation of domestic violence is filed, even if a child didn't allegedly witness it, if a child was in the home, that's an automatic referral. If a child goes to a hospital in the state of New Jersey with a broken bone under the age of 1, automatic referral. This is hospital policy. That does not mean there's a genuine belief that an act of abuse occurred, but there's this problem that we have to have investigated. And we're going to let the people who know how to do that investigation do it.
So when DCPP becomes involved during that ongoing custody or divorce matter, how does that, kind of change the legal landscape?
In two ways, because sometimes the referral does indicate a genuine issue. Sometimes it's a substance abuse issue by one of the parents. Sometimes it's acts of physical abuse against the spouse or the children. Sometimes you can see really significant alienation can cause children to have physiological reactions, anxiety, stress, panic attacks, that when they display those behaviors can cause a referral to be made to the division. Sometimes, though, it's one parent's real mad at the other one, and they call in a referral that, they've been married 15 years, their children are 12 and 13, and for 12 and 13 years, there's never been a concern about child abuse of any kind, and suddenly now that we're in the middle of a divorce, there's a big old concern about child abuse. So some referrals are more significant in a divorce case, and some look like opportunistic.
What rights do parents have during a DCPP investigation?
I think parents have more rights than they might realize during a DCPP investigation. And I'll say the investigation it's a weird thing for a parent to go through. It's, these are caseworkers who have your children's best interests at heart, but a lot of parents don't realize you can refuse to allow your child to be interviewed by an investigator. You can refuse to allow an investigator inside your home to see it. However, exercising those rights does come with some risks, because if there's a genuine concern by a caseworker that this child is in imminent risk of harm and the parent is not complying with the requests of the investigator has the legal right to remove the child. So it's very difficult to determine what the absolute, objective best decision by a parent is in advance. You have to really take it as it comes. And you can have an attorney involved early on before there's a legal case. Most DCP investigations do not go to court. There's not an abuse and neglect case opened in most of those cases. A lot of investigations get closed, some without any recommendations, some with some minor recommendations. But you can have an attorney involved to help advise you along the way.
How does the court distinguish between that, a temporary safety concern and maybe a more serious finding that could affect custody long term?
So in a lot of cases, it's not even the court making the decision. I'll say a lot of times it's pre-court action. It's the division saying, all right, we got this referral. We've had these discussions. We think that this was a short-term or potential problem. Here's what we recommend you do. Whether that's, if you got a child who sleepwalks and was found out in the street in the middle of the night, and you got a referral because there was a child unattended in the street in the middle of the night, but nobody thinks that there was an act of abuse that led to that. The recommendation might be, all right, put alarms on your doors so that, if the child sleepwalks out of the house, someone's made aware of it. Or, things like that. Improvements to your house. Does the child need counseling? Is it recommended that the parents attend counseling? Those are recommendations that can be implemented, and as long as they're being undertaken, the division may not feel like any further action is necessary to ensure the safety of these children. If it's a longer or bigger problem, if it's a physical abuse problem, if it's a substance abuse by the parents problem, if the children don't have food, if they don't have clothing, if they're not attending school with regularity, the division may open up an abuse or neglect court action and ask for court orders to help enforce compliance and to get the resources to the family that they need. But the goal is still reunification, and the goal is to close the case because the risks have been eliminated.
What role do evaluations, like the home visits and the caseworkers' reports play in these family court proceedings, though?
They're very important, especially early on. Sometimes the caseworker, does the early reports, and the court decides that it needs an expert to do a separate evaluation, sometimes a psychiatric evaluation or a substance abuse evaluation or an anger management assessment. Those may go to separate experts, but the initial intake and the initial findings and the initial representations to the court about how the children are doing, that's coming from the caseworker. The caseworker is going to assess, is there food in the refrigerator? Is the house, infested with rodents or insects? Did the children have bed bugs? What's going on there? That's the firsthand account from the caseworker, and the court's going to take that very seriously.
Can DCPP involvement automatically change custody arrangements, or does the court still conduct its own independent analysis?
So automatic is, again, a difficult word for us. The division does have the authority to do an emergency removal and take custody. Like, the division can have custody of the child. Then the child can be placed in a temporary foster situation or with kin, a relative of the parents, depending on what they think is most suitable. Sometimes they end up in a shelter temporarily. But in a really emergency situation, the division itself can do a removal. Other times the division can seek the involvement of the court, and in conjunction with or separate from a custody dispute between the parents, the division can make recommendations about where they think the children are safest and what restrictions might be required on the other parent. So does one parent require supervision for their visits for a while? Or would they be comfortable if that, let's say there's an alcohol issue, not uncommon. That parent might have to use something called like SoberLink or some other mechanism to demonstrate sobriety prior to or during visits. And that's usually done. Sometimes that can be done by consent, but it often is also a part of a court order.
Have you handled a case where DCPP involvement initially caused panic for a parent, but the situation ultimately resolved differently than they expected? Without sharing those details, of course.
I'll say one of the best examples I have ever seen is there was a mother who became convinced, partly because she herself suffered from mental illness, she was convinced that the father was abusing the children and was trying to poison the household. So she made a referral, and then she tried to remove the children from the state. And the division began its investigation with dad as the expected defendant. And what they realized pretty early on is that it's actually mom who was the risk to these children because she was suffering from this untreated mental illness. And then once she was diagnosed, she refused to comply with her medication. So at that point, mom became the defendant, and the court determined, and DCPP determined, that the children are in fact safer with dad. That's one of the more dramatic turnarounds I've ever seen, and I'm actually really impressed at how quickly DCPP was able to identify that, because I respect that there's a presumption that somebody's making a report in good faith. They're making a report because they genuinely, and mom did genuinely believe it. She just had this other issue going on. But sometimes it takes a lot longer to kind of turn that boat when the referral is based on erroneous information.
So if a parent believes a report to DCPP was made maliciously or strategically during divorce, how does the court kind of evaluate and kind of sift through that?
I'll say if it's a one-time thing, almost nothing happens. They're going to presume good faith if it happens once. If you get to a situation, there are some really extreme situations where there are referrals being made regularly, or the day before parenting time is supposed to go to the other parent. You can look at those patterns. That can give rise to a finding of harassment, the entry of a restraining order, a change in legal custody. There are a lot of things that can happen if one parent is, I'll say, abusing the referral system for their own agenda.
How does, DCPP findings impact future custody or parenting time decision once the investigation is done?
In some ways, it depends on what the findings are. So if abuse is established, it's pretty clear something needs to be done. And in contrast, if a referral is determined to be unfounded, then they do not believe that there's a problem, and they're going to stay hands off. It's the gray area in between that custody between the parents is most impacted. So that's called the not established standard. And it's really, really gray. It's a really gray area. Sometimes you'll get a letter where all it says is the referral on such and such a date was determined to be not established. We're closing the case. Okay, but it doesn't give us any information about what the finding, not what the factual findings were, but what the process was. What was considered? What did they find in the investigation that maybe doesn't rise to the level of abuse, but might be of concern to a parent and might need to be resolved? There are some division caseworkers who write, better letters that include more information that is actually useful in caring for these children and making decisions going forward. Attorneys can petition the court and ask to review a DCPP file. There's a whole process. You have to file a motion. You have to serve the Deputy Attorney General because they have the opportunity to come into court and say, no, we don't think this file should be reviewed. It's a little easier for attorneys to be allowed to review the file than it is for the parents themselves. And I think that it's pretty easy to understand why. There's a professional objectivity. But even if the court says, all right, I think these files are helpful, the court has to review the whole thing in what's called in camera before deciding whether the attorneys can see it. And that can be a time-consuming exercise. So sometimes it really can delay things.
For a parent who receives that first phone call from DCPP and feels overwhelmed, what's the most important step they should take, right now?
Don't panic. Do not assume that there are caseworkers out to get you. That is almost never the case. I was going to say rarely. It's less rare than rarely, or less often than rarely. Call your attorney, because most people don't go through it often. Sometimes it happens more than once, but oftentimes there's a lot of nothing there. I'm lucky in the area in New Jersey where I am. A lot of the referrals end up being unfounded, or they're not serious in the same way that other areas of the state or the country might have an overwhelming number of serious abuse allegations. But call your attorney. The caseworker often will give you some information. They won't tell you who the referral is from, but you'll get some information about which child they're concerned about, or what they need to look at, or what they need to do to interview the child.
That wraps up today's episode on For Better or For Court. If you're navigating a divorce or a custody matter and a DCPP becomes involved, visit HeymanFletcherLaw.com to connect with Ms. Alex and understand your rights under New Jersey law. Don't forget to like, subscribe to the show, and leave a review if you found this episode helpful. Thank you all so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.